Welcome to S&C Sidebar, our podcast where we talk with our partners about the most interesting legal issues they've seen in their careers, what they're seeing on the horizon, and other topics. I'm Annie Ostrager, the co-head of S&C's Employment Law Group and a member of our Workplace Investigations, Criminal Defense and Investigations, and Trade Secrets Group. I'm joined today by my partner, Ollie Engebretson-Schooley, who's a partner in our litigation group and resident in our Washington, D.C. office. His practice encompasses a wide range of complex civil litigation matters, including securities litigation, shareholder derivative litigation, books and records demands, and mass tort and consumer class actions. I've had the pleasure of working with Ollie on a number of these types of cases, and he's been my partner since January of this year, so I'm delighted to talk with him today.
Thanks, Annie. Delighted to be here.
Great. Let's start by talking about some of the most interesting issues that you've worked on in cases throughout your career.
Sure. Gosh, where do I start? So I really cut my teeth on litigation as an associate during the pandemic and in litigation related to the Paycheck Protection Program, if you remember that. Those were cases that were moving very quickly. We had a lot of them. I think at one point we had 24 active cases across the country, but these were suits that were being filed against participating banks, but they were being filed by customers and applicants and third parties who had assisted the applicants. And of course, the financial institutions were trying their best to stand up this program and get the money out to the people who needed it. So it was a great lesson in exercising judgment and providing thoughtful but concise advice on a short time frame and really helping these financial institutions play this critical role rather than becoming another roadblock for them. And it was a fascinating case because it was one of those rare cases where you have entirely new legislation, an entirely new set of regulations of the CARES Act and the implementing regs. Also, a lot of my practice focuses on securities litigation and derivative litigation. You often see those paired now because they both are very often filed, after a company faces some sort of big public corporate trauma. I find those cases fascinating, and I really enjoy doing them. Delaware law on corporate fiduciary duties is also changing. There's a changing notion of what is the type of risk that a board or executives should be monitoring? And a lot of the discussion amongst practitioners and the courts on what qualifies as an adequate response to those risks, all of that is very active and changing. So it's a great area of the law to be practicing in.
How have you handled advising your clients in these areas where the law is evolving, or as you said, there is no roadmap because you're dealing with new legislation or an emerging risk?
Yeah, it's a good question. I think the two things that come to mind are, one, you really have to listen to your clients and understand what their needs and concerns are. And I know that can be hard for lawyers to do because we like to argue, like to stand up in court, especially litigators. But you can give them a sort of dry answer of here's what I think the law is, or here's how the best way to read this statute. But that's not really going to help them because they need to know for their particular business or whatever it is that they're engaging in, what are the risks for that specifically, and what other considerations should I be taking into account, whether it's reputational concerns or the like, especially when you have a new issue that doesn't have a lot of built-in guidance or case law already. Understanding all of those considerations, not just kind of the really doctrinal legal issues, is critical to providing clients with the best advice.
We talk a lot about our unique approach and multi-specialist approach. How would you say that has affected your practice?
Yeah, I think it's been critical. While I have areas of focus, like I said, I do a lot of securities work and shareholder derivative work. I consider myself a true generalist. I've done consumer and mass tort class actions. I've done antitrust litigation. I've done general commercial disputes. And in fact, Annie, the longest matter I've had since I've been at the firm has actually been a criminal defense matter. The best way to learn how to be an effective advocate is to get comfortable jumping in and out of different areas of the law. Clients come to us when they have unique or complex problems and ones that they haven't dealt with before. So you have to be nimble and you have to be able to build the skill of quickly understanding how an area of the law works and also being able to recognize the patterns. Sometimes you'll see an issue that comes up in one area that you've actually dealt with in another. And so you understand some of the implications of the issue and how to think about it and what may have worked or have not worked in a different context. And all of that is incredibly useful to the clients. And so I think coming up in a generalist practice has really helped me build those skills, being able to recognize those patterns and building that ability to jump into issues quickly.
Let's talk a little bit about advice you might have for associates as they're working through their own careers. What would you tell them to do given your own experiences?
A couple of things come to mind. One is take initiative. I think some of the best associates that I've worked with, and where I think I was able to develop really great relationships with partners when I was an associate, was when there was some new development in a matter, rather than just telling people that this was happening and then sort of waiting for direction. If you can say, okay, this just happened, and here's what I'm planning to do about it, or here's my proposal, and presenting that to the rest of the team and the partners, you become a much more effective member of the team. And you also can build trust with partners and your colleagues that they know that if this comes up in a situation where there may not be time to ask everyone on the team for input or get the direction, they trust that you have the judgment to know what to do on your own in those circumstances. So that's one thing. And the other is just be collaborative. Everything I've learned has been from my colleagues. And I learned that by asking the questions and getting their input. And even when I think I'm right, running that by folks down the hall just to get their reaction. And sometimes they say things that I didn't think about. And so being comfortable with being collaborative and asking questions and getting other folks' input, I think is also really critical to building relationships, but also building your skills as an effective lawyer.
I think that's great advice. And picking up on that theme of relationship building, I think that's also an incredibly important skill with clients and something that I know you've done very effectively. Maybe talk a little bit about an important relationship that you've built on the client side and why it's been important in your career development.
There's a couple of clients that I've worked with since I started at the firm as a young baby associate. And those are really the most rewarding client relationships because I've been able to sort of start observing and seeing how other partners interacted with this client or these clients, and then slowly start to build that own relationship on my own. And I think in a couple of those cases, the ones that come to mind, where you start to really build the trust with the client is when you start anticipating questions and needs that they have. And it's not just a relationship where they have a problem and they come to you. Some of the examples that I'm thinking of are if we see something that is happening, for example, in the shareholder derivative space, we see plaintiffs firms bringing these new types of clients. One good one, and I actually just wrote an article about this with a couple of colleagues, is plaintiffs now bringing derivative Section 10B claims, which is a sort of a totally new area. And we really hadn't been focusing before. And identifying those issues and then bringing them to some of these clients where we've had longstanding relationships, bringing them to their attention and saying, hey, have you thought about this? We're seeing it a lot more. It's a risk. Like, let's talk about it and see if there's ways that we can help mitigate it. That's really where you start to build the trust, because then they realize that not only are you thinking about them, even when you're not just handling a matter that they've given you, but also that you understand their business well enough to be able to identify those risks. I think that's really the best way to earn clients' trust.
What are areas you're watching right now for your clients that you think should be on their radar screens?
So one is what I just mentioned, which is the uptick in derivative litigation for Section 10B claims. And we're seeing that a lot more. And I think more broadly, over the past 10 or 15 years, we've really seen a significant increase in damages amounts for settlements in derivative cases. Cases used to be much smaller value cases, and they were more focused on corporate governance reforms. Now you're seeing settlements with 7, 8, 9-figure damages amounts. There's a number of different reasons for that, but I think what companies need to be aware of is these are risk areas for them, and a lot of the risk can be addressed. It's fascinating how many of these cases are often decided on what was in a particular board report or what was included or not included in minutes. And so if companies are being proactive about not only ensuring that they have the right corporate governance in place, but also ensuring that that corporate governance is well documented, I think that's really critical to protecting them against these types of cases that are becoming more of a risk. And the other area too that I think is fascinating is the issue of class certification in securities cases. Back in 2013, there was a decision from the Supreme Court, the Comcast decision, where I think a lot of people thought that it could really bring in a significant change in how courts think about class certification and the standard that plaintiffs have to prove to certify a class in these cases. And we didn't really see that. But over the past year or two, some of the circuit courts have started to take a closer look at that. We see it in the Fourth Circuit, we've seen it in the Sixth Circuit. All of these issues are still very young, and we haven't seen any significant decisions yet, but it's an area where we're watching closely because these class certification of securities cases is a really important inflection point. And so it could really be a game changer if some of these circuits come out with significant decisions on this issue.
We worked together on a matter that could have had really significant ramifications for an entire arm of our client's business had we not successfully litigated the case, which we did. How have you worked in your practice to understand the businesses of your clients, which can be really important to the legal strategy? And how have you really dug in to make sure that that gets incorporated into litigation strategy?
Yeah, and that was a fascinating case as well. You really have to take every opportunity you can to ask clients questions. And oftentimes in the day-to-day with clients, you're very often speaking to, your legal counterparts in-house. And so sometimes it's critical to bring into those conversations and early on so that from the beginning, folks on the business side who can help explain whether it's a particular business line that's at issue or some new endeavor or some new program or service, help explain how does this work? Why did we do it this way? Why do we have these protections or policies in place? And so bringing those folks into the conversation very early is really important. Even at the first stage of the litigation, when you're writing your motion to dismiss, for example, in the case, Annie, that you just mentioned, this was all being litigated at the pleading stage. If you don't understand that piece of it, you can't tell an effective story. You can't, and in a fulsome way, explain to the court, why is this the outcome that makes the most sense? Why is this the one where you put it all together seems like the right outcome if you don't have the business side of that? But over the course of the case, you get it too, as you're prepping witnesses, as you're building summary judgment or trial themes, all of that, you have to take every opportunity when you're speaking with folks on the business side to learn about what they do, why it is that they did it. Like deposition prep is not just about putting documents in front of folks and working through how do you answer questions. It's about understanding the big picture.
Well, thank you, Ollie, and thank you everyone for listening to S&C Sidebar. For more information about our practice, please visit us on the web at www.sulcrom.com.